All right, the next case on the docket is BRASSBOYS versus Lakeside. All right, good morning. May I proceed?
May it please the Court, Daniel Bushell on behalf of the appellant BRASSBOYS Enterprises, Inc., and I'm here with my co-counsel Britton Mitchell, and in the audience is my other co-counsel Gregory Williams and my client's representative Clark Smith. I'd like to reserve 5 minutes for rebuttal.
Okay.
The primary issue in this appeal is the trial court's refusal to order eviction. It should have been a simple issue. Everyone agreed, and the trial court found, that the 2001 ground lease was valid. It was stipulated that there were not 1 or 2 breaches, but 14 breaches by non-payment, in addition to non-monetary breaches. And the breaches, at least for the monetary ones, were intentional. There was a testimony expressly that we made a decision not to pay the rent. And the lease expressly empowers BRASSBOYS to evict if there was even a single breach, and here there's 14. And it expressly states that in the event that the lease was terminated, improvements would become the property of the lessor. Now, Lakeside Bay was given 9 separate notices of its breaches.
Is the notice issue even relevant in light of the trial court's finding? The trial court in their final judgment made no reference to the failure of notice, correct?
That's correct.
Okay, so aren't we just entirely talking about the issue of equitable estoppel and whether or not the the conditions in this case justified the judge denying the eviction based upon equitable estoppel remedy?
Yes, I would agree that should be the primary
Could you address the elements of equitable estoppel and how you believe that the appellee failed to meet the threshold requirement to have equitable estoppel available to them as a defense?
Well, the equitable estoppel that the trial court found, at least according to its, if you take the trial court's amended judgment at its word, was that BRASSBOYS was stopped from denying the validity of the lease. I don't have a problem with that finding in itself, but it doesn't have anything to do with whether we can evict or not. We don't need to have an invalid lease to evict. Quite the contrary, the fact that the lease is valid.
Well, did your client ever take the position down in front of the trial court that the lease was invalid?
That was not our litigation position whatsoever. It was not in our amended complaint, and it was not what we argued at trial. There was some discussion before litigation or before the circuit court case was filed as to whether the lease was valid.
The wrong party to sign the lease, that was kind of the issue? Is that?
I'm sorry?
Was it the wrong party signed the lease? Is that what the issue was? I mean, it really wasn't the fee owner or something?
Yeah, they were.
But I mean, it was related companies or something?
Yeah, there were 2 issues. One was that it was the lessor was misnamed,
Yeah.
and the second was that there were not 2 witnesses to the lease. Originally, actually, it was Lakeside Babe that was contesting the validity of the lease. And in some of the letters that were, in some of the notices that were sent to Lakeside Babe, it was stated that if the lease is valid, or it was kind of conditional about whether the lease was valid or not, but that was not BRASSBOYS' litigation position whatsoever.
Okay, what is, we have certain elements of, it seems to me like the judge basically founded the ruling on equitable estoppel. It seems as though the trial judge was concerned about if there was an eviction that there would be a windfall to the other party based on all of the construction that had been done and the money that was spent on the property. So what is your strongest argument? You've got several elements of equitable estoppel. What is your strongest argument to this court as to why equitable estoppel doesn't apply in this case. Do you know what the elements are? You've got one
Yes,
representation.
well, first of all, there was no misrepresentation made whatsoever about eviction. The testimony was clear that Brass Boys constantly demanded the rent. They never, the testimony was that Brass Boys had never lied to Lakeside Babe, and that they certainly hadn't said, we're not going to evict you if you don't pay rent. So the equitable estoppel here doesn't get you to equitably stop from pursuing eviction action. My belief is what is...
Are any of the elements established in this case? You've got representation, reliance, and a change in position. Are any of those elements established in this case?
No. And like I said, the way I understand the trial court's amended final judgment is that the equitable estoppel was as to denying the validity of the lease, which there's a logical leap missing there between that and denying eviction.
Well, the trial court also focused on the improvements that were made to the property and said that it would be disadvantageous or unfair to the lessee to have the lessee make all these improvements and basically construct what it was, the structure and the building, and all of that would then go back to the mortgagor or the lessor with regard, and they would have the benefit of all that. It was more than just whether or not the lease was valid or not, correct?
Correct, and that was what the trial court called unjust enrichment, which was, by the way, not a defense that was pleaded, and we objected to that issue being even tried. But what I think that the trial court was really getting at was these anti-forfeiture principles, which are, again, are not, there was no such defense pleaded. And as we set forth in our brief, there's at least 4 different reasons why that defense should not have applied here. Number one being that the case law is clear that the law will protect you from a forfeiture only when your conduct is innocent, not when your conduct is intentional, and not when your conduct is repeated. And it's not just one isolated breach because you can't pay, it's intentional over and over again breaches. Third is that we have here commercial parties who had equal bargaining power, were represented by counsel, and they specifically contracted for this remedy. In fact, the lease was written by the lessee, and this remedy was explicitly included in the contract, and it was explicitly contemplated that they might make improvements. That was the raison d'etre, actually, of the contract was to make improvements.
How long a period was it there was no rent? Was it like over a year?
I believe that's the case, yes.
Yeah.
Were there any improvements that were made after the county court action for failure to pay rent was filed?
Yes, that's the $125,000 that the trial court referred to in its amended final judgment.
Was that after, there was a sublease, correct?
Yes.
And the sublessee quit paying evidently, is that what happened?
Yes.
And then the lessee, in your case, I guess, said, look, they're not paying, we've got an action going to evict them. Then they ultimately did, I guess, right?
Yes, they did.
And then they spent the $125,000?
Correct.
Okay.
Because after...
To make improvement, it was a restaurant, wasn't it, or something?
Yes, it was a restaurant, and essentially what Lakeside Babe had told my client was, help us get out this subtenant and then we'll pay you our rent, and there's an email on the record which says that, and my client helped them to evict,
Okay.
and then they still didn't pay the rent.
Okay.
And instead they went and did some cosmetic improvements that my client objected to, and for which there was no consent sought from my client in advance, as is required under the lease. And our position is, and it was after litigation had already been instituted. So, I mean, that's like, you don't pay your rent, you're being evicted, I'm going to go paint the house, and now you can't evict me because I painted the house and I improved the property, which is basically what the trial court allowed to happen here. And we would contend that, as a matter of law, that the trial court didn't have, it was improper to apply these anti-forfeiture principles here, not only because it wasn't pled, but also because it doesn't apply to an intentional violation, which is repeated, and basically they undertook the risk. They know that they're not paying their rent. They know that we're making demands for rent. We've even filed a county court action. So then they're going to go and spend $125,000 and say, oh, you can't evict us because we just spent all this money on there. That would be unjust. But then why did you spend the money? You knew that you weren't paying rent. Why didn't, instead of spending $125,000 for improvements, why didn't you pay your rent? Which is what they were required to do. And if the court's going to allow that to stand, I mean, what's going to stop them from doing it again? They can't be evicted. What was really about was lower rent, and we're not going to pay your rent. You got to give us lower rent, otherwise, you're just going to have to wait for your money, and you can't evict us anyway because that would be forfeiture. And that, that's basically what occurred here. Unless there are further questions, I'm going to reserve the rest of my time.
Okay.
May it please the Court, Angela Flowers on behalf of Applee BRASSBOYS, and I'm here as well with representatives of BRASSBOYS, Lakeside Babe. Angela Flowers, here on behalf of Applee Lakeside Babe, along with representatives of the Applee. Don't know how I got that one mixed up.
We knew who you were talking about.
Ms.
I'm sorry.
Flowers, talk about the equitable estoppel issue, because I'm a little bit concerned about that. I have a difficult time seeing why the trial judge kind of hung his head on that one.
Well, Your Honor, let me start with the fact that we are here on appeal from a final judgment entered by Judge Thomas after a bench trial, where there was extensive evidence, both testimonial and evidentiary, which was submitted at trial. And there is competent substantial evidence which does support all of the findings entered by Judge Thomas. This starts, in fact, with...
What are the findings, and what's the evidence relating to a representation as to a material fact that is contrary to a later asserted position? What is that?
Well, if I can begin with a misstatement of fact that Applee may have provided to the court, that would have to do with whether or not BRASSBOYS at any time denied the validity of the 2001 ground lease. And in fact, they did in every one of their complaints, including the operative complaint, the amended supplemental complaint in paragraph 9, of which they claimed that the attached 2001 ground lease was invalid.
Well, I understand the position they took, but basically the judge resolved that by finding that the 1998 and the 2001 leases, the amendment in 2001 and the 2001 ground lease were all valid, correct?
Correct, but
So
this...
then aren't we talking about, okay, if they're valid, then we're talking about what are the terms of those leases, and specifically in the terms of that 2001 lease, it addresses improvements to the property, and that if there is a termination or eviction of the lease, then those improvements go back to the lessor. Is that correct?
That would be correct, but there is no automatic forfeiture just because of the failure to pay rent when there are sufficient defenses to that failure to pay rent. And this goes back to prior to the judge making that finding in 2012. This case begins in January of 2011, where it comes to light that there is a question about the validity of this 2001 lease. And when this first comes up, from the very beginning, BRASSBOYS takes the position that the lease is invalid, and in fact produces a 2008 lease, which it says is valid.
But that was in this case, correct? In other words, in this case, they took that position initially.
Correct,
Right.
correct, from
In
the
other words,
beginning.
It's not judicial estoppel, though, correct? I mean,
No, this is...
judicial estoppel is when you take a position in another case that's different than the...
It is not, Your Honor. It's
Yeah,
equitable
yeah,
estoppel here.
Yeah.
Because, and if I can, just let me give a little bit of the background of the facts, because this is a very complicated course of dealings between the parties. But when the subtenant stops making payments of rent,
Right.
Lakeside Babe, as the sublessor, the tenant, to Brass Boys.
Right.
Turns to Brass Boys and says, I have a tenant who's refusing to pay rent. There's something about the lease not being valid. What's going on? At that time, Brass Boys, separate and apart from that litigation, which they acknowledge is a problem, and that they agree to come alongside Lakeside Babe and try to correct and go against the subtenant, separate and apart from that. Brass Boys says, well, okay, that 2001 lease, we're taking either one of two positions, and they don't commit. They take inconsistent positions. Number one, that 2001 lease is invalid, not only because, yes, there are these technical defects to the lease, but number two, because we entered into a 2008 lease, and we think you're part of that lease, by the way, and that's the lease that we want to enforce against you. And that's why you see the initial complaint in the county court case by Brass Boys against Lakeside Babe raises the enforcement of the 2008 lease, a document which Lakeside Babe had no knowledge of until all this litigation began. So we have rent being withheld beginning in February, and we have this position being taken. Beginning in April, Brass Boys and Lakeside Babe are working intensely together to partner to fix this problem. So here's where you have your material misrepresentations, both as to the status of these leases and then also as to the representations that we're going to work through this with you. We need to enter a second or a new, maybe this is a third, we need to enter a lease that's valid. And Lakeside Babe says, we're ready, willing, and able to enter a valid lease. So you begin having all this back and forth. As you go through the testimony, you'll see there are lunch meetings that are going on. The principals of the two corporations are sitting down and they're talking about how they're going to work all this out. And Judge Thomas heard all of this evidence. And so it goes through this April, May, June. In the meantime, because of these ongoing negotiations and conversations, Brass Boys isn't prosecuting that county court eviction action. It's just sitting there. As a matter of fact, there's so many letters and emails that go back and forth in this case. You'll see an email in June where Brass Boys' attorney says to Lakeside Babe, don't bother depositing rents into the court registry. We're going to work all this out. So this is going on all through April and May and June. It culminates with letters in June and meetings into July where Brass Boys is saying, we're going to dismiss our eviction action, and what we'll do is, we'll file an action with you, we'll do a circuit court declaratory judgment action, one or the other, because ultimately we need to figure out whether this is a valid lease or not. So they end up joining, Brass Boys and Lakeside Babe file a joint complaint against the subtenant at some point, and they're seeking declaration. Well, through negotiations, because all these parties have worked together for years and years and they know each other, Brass Boys convinces the subtenant, Vandervalk Inverness, to move out of the restaurant. Okay, so we get up to that point. Now, at that time, there are much more intense negotiations about entering into a new lease. Again, extensive evidence on this in front of Judge Thomas, which she had to consider as to this equitable estoppel defense. The Lakeside Babe retakes possession of the restaurant. At that time, Brass Boys knows that they're doing it. As a matter of fact, at one of these lunch meetings between the principal of Brass Boys and Lakeside Babe offers Mr. Smith an interest in the restaurant. He says, why don't you come in to be partners with us? You know, we're going to do these huge renovations. This is going to be a 5-star restaurant. Do you want to be a part of it? Mr. Smith declines. Lakeside Babe goes forward. They invest $125,000 in renovating this restaurant. There's a partnership going on because Brass Boys has this clubhouse and golf course, and Lakeside Babe is providing the restaurant that's going to service it. Lakeside Babe goes to Brass Boys and says, can we use your logo? We'd like that to be part of our restaurant presentation. It's in the evidence. All of this testimony that Judge Thomas heard. Brass Boys says, sure, there's an email in the evidence where they give authority to Lakeside Babe to use the logo. This is in July when the renovations are ongoing. So all of this was reliance by Lakeside Babe. that they were negotiating a new lease, there was going to be a valid lease put in place, the restaurant was ongoing, everyone was on the same page, we're using your logo, we're all in, in this together, and they opened the new restaurant in October, and Brass Boys files a new lawsuit for eviction in circuit court. That's how we got here. And that's why Judge Thomas, based on extensive, competent, substantial evidence, found that Brass Boys is equitably stopped from evicting Lakeside Babe from the property.
Did Brass Boys know the terms of the sublease?
Yes, they signed a,
Did they have
not a
to-
ratification, but they signed an acceptance of that sublease.
So they knew what the rent was, correct? I guess.
Absolutely. Yes, Your Honor. Yes, they did.
And they knew what the remedies were as far as any improvements made to the property, and if the sublease came to an end, where those improvements would go, correct?
Well, those improvements were were made under the original lease, the 2001 lease, that was assigned from, we had Brass Boys who entered into a lease with Vandervalk Lakeside. And then Vandervalk Lakeside constructs the restaurant property with financing from Lakeside Babe. When Vandervalk Lakeside can no longer make the payments on the financing of the restaurant, it turns to Lakeside Babe to do a workout. The workout was the assignment of this lease from Vandervalk Lakeside to Lakeside Babe, where Lakeside Babe then entered into a sublease with a newly created Vandervalk Inverness, who comes into possession of the restaurant in order to run the restaurant. And so, yes, we have this sublease, which is then accepted by the original owner, lessor, Brass Boys. Yes. So, based on all of this, Your Honors, what we have is a situation where we have a highly complex commercial lease situation with parties who were dealing with each other for many, many years. And we have an ongoing course of dealing between the parties in terms of trying to work through the fact that it came to light that the 2001 lease had some technical insufficiencies to it, which made it perhaps facially invalid. Ultimately, the trial court upheld the validity of the lease on the ground of the course and dealing of the parties over all these years. They had, in fact, acted on all the terms of the lease when Vandervalk Inverness had been the lessee. It had performed its side of the lease, it had constructed the restaurant, and because of all this, the court determined that the 2001 lease was in fact enforceable. Now,
And the trial court determined that the lessor was entitled to all the past due rents, correct?
correct, the lessor, Brass Boys, has been made whole in this case by the payment of all rents. As a matter of fact, after in June 2011, when Brass Boys said you don't need to deposit the rent in the court registry, things kept going along. When things started to get a little rocky in September, before Brass Boys files the October eviction, when it seems like perhaps, they aren't going to be able to renegotiate this, or to negotiate this new lease, Lakeside Bay begins putting the rent monies into its attorney's trust account. So Lakeside Babe sets aside all this money in September, right before the new October eviction action gets filed. When the October eviction action gets filed, Lakeside Babe immediately files a motion for determination of rent so that it can make a deposit into the court registry, because it doesn't know what it owes. Brass Boys is claiming that there's this 2008 lease out there, which is the operative lease, and then there's the 2001 lease, and there's questions about how Brass Boys has calculated the rent that it alleges is due in the complaint. So Lakeside Babe files this motion to have the amount of rent determined. Brass Boys doesn't set that motion for hearing for 6 months. for some reason. But the minute that the motion comes on for hearing and that the court determines the amount of the rent, all those funds which have been held in the attorney's escrow account are deposited into the court registry, and then monthly payments are made thereafter. So there was never any insecurity about the ability of Brass Boys to be paid its rent. And that's one of the considerations when you look at the application of equitable remedies. You know, the trial judge looks at this, and we know that the purpose of a forfeiture clause in a lease is in order to secure payment of rent. And so in this case, that element was checked, its box was covered, because there was never any doubt here that Brass Boys was going to be secure in having all of its rent paid. Ultimately, the trial judge, in addressing the declaratory judgment aspect of the complaint, affirms there that the 2001 lease is in fact valid and enforceable. And in doing so, the court was asked to look to whether or not there had been an oral modification to the lease. Now, Brass Boys took the position that there was an oral modification that had replaced the parcel, the 5.5 acre parcel, which was referred to and described in the initial 2001 lease, with this mere 1/2 acre parcel that the restaurant covered. But the trial judge correctly applied the law to find that the 2001 lease remained enforceable in its entirety and conferred rights upon Lakeside Babe to the full 5.5 acres. Lakeside Babe had been continued to use the parking lot. There had been a period of time where it had an office in the clubhouse building, and all these other areas that were encompassed within the original lease and the description of the premises that was demised through the lease. But in addition to that, the trial judge determined that there had been an oral modification, that there was an additional parcel to be included in that 2001 lease, and that would be the parcel that the restaurant sits upon. And that was because when the original lessor and lessee, Brass Boys and Vandervalk Inverness, Vandervalk Lakeside was the original lessee, when it came time to build the restaurant premises, Vandervalk Lakeside was unable to get a building permit from the county to build the restaurant on the area of land within the 5.5 acre parcel described in the lease. So the parties entered that, informal agreement, which became the oral modification to the lease, that you can build the restaurant over there. And that's what they do. And that's why the trial judge determined that there had to be a finding that there was an oral modification to the 2001 lease to include the restaurant parcel. And that's separate and apart from the fact that Lakeside Babe continues to have the rights to use those other portions of the premises which are encompassed within the 2001 lease, and which in fact it had been using for all these years. We ask that the appellate court affirm Judge Thomas on all rulings in the amended final judgment. The trial court had competent substantial evidence upon which to make the determination that Brass Boys was equitably estopped from evicting Lakeside Babe from the premises. Brass Boys' position that there is an automatic entitlement to an eviction no matter what is an incorrect statement of the law. The court always has the opportunity to exercise her equitable discretion and to look into any valid defenses that are of an equitable nature. Here there was substantial competent evidence to support the finding that Lakeside Babe had relied upon material misrepresentations by Brass Boys, beginning with a misrepresentation as to what was the valid lease, continuing through those misrepresentations of how they were going to work together to enter into a lease that they both could agree was a valid lease, and then ultimately also making material misrepresentations about its position about Lakeside Babe being able to go on and renovate the restaurant and use its logo, and all of this up until the point that Brass Boys changed its mind on all of those points and filed the circuit court eviction. So based upon the evidence, we ask that the court affirm as to the denial of the forfeiture and the eviction under the lease, affirm that the trial court was correct to award all past due rent payments to Brass Boys and to make them whole in that regard, and affirm the court's ruling as to the proper interpretation and application of the 2001 lease as orally modified by the properties. Thank you, Your Honor.
Let me first start out with the equitable estoppel argument. It's interesting that my colleague is essentially asking this court to retry the case. The trial court made findings of what it thought was the equitable estoppel. It wasn't about the litigation conduct. It wasn't about the letters that had been sent back and forth. It was the fact that my client had accepted rent payments from Lakeside Babe, and that therefore it was stopped from denying the validity of the lease. There was no finding that there were misrepresentations that they could, based on negotiations, or that Lakeside Babe could stay there indefinitely without paying rent. To the contrary.
Did your client tell them they didn't have to pay the money into the court?
There may have been a time when that was said, but that was not a position that was maintained throughout the litigation, and there were constantly letters.
The trust account then, and ultimately into the court?
Over a year later, and that was only after they had filed the motion to determine rent, and then never set it for hearing in the county court action, I believe it was, and then over a year later, we had to actually file a motion and set it for hearing and get that issue determined. But the entire time, there's letters going back and forth saying you're beginning in April and in May, in September, in October, in November, in December. There's letters from Brass Boys saying you need to pay the rent. And the testimony of Lakeside Babe's representative was every time he met with Mr. Smith, the representative of Brass Boys, he demanded the rent. There was never a representation that they didn't have to pay rent and they could stay indefinitely. Whether or not they were trying to negotiate another lease, and there's conflicting testimony on that point, they never said they didn't have to pay rent. They never said you can stay here indefinitely. And there's documentary evidence in the record which shows very clearly that on September 8th, which is about 2 weeks after the renovations began, Brass Boys hired new counsel, and he immediately sent a letter to Lakeside Babe saying, we did not authorize these renovations, stop making them. We did not authorize you to bring a new company in there, get it out of there. So that's why the trial court did not find that there was equitable estoppel on that basis. And I'd just like to correct, I did misspeak. There was apparently one paragraph in the complaint questioning the validity of the lease, but at trial that position was abandoned. That was never urged at trial. As to the 2008 lease, there was a stipulation that it was invalid, so that was never pressed at trial. And aside from the fact that the evidence which the trial judge considered, which shows that there was never a representation that don't worry about paying rent, it would be unreasonable as a matter of law to rely on such a representation after you're in litigation. I mean, you can't rely on your opponent in litigation for anything. And again, this is not the equitable estoppel that the trial judge stated. She stated what the equitable estoppel she thought it was. But the problem for the appellee is that it doesn't lead to the conclusion that you can't evict. It only leads to the conclusion that the lease is valid. I want to address briefly the boundaries of the parcel. The trial judge here, as my colleague acknowledges, basically acknowledged that there was an oral modification to the lease. But the only evidence in the record of the oral modification was by the two parties to this oral modification. They both testified that the restaurant parcel was substituted for the original parcel. And the facts on the ground are, the restaurant was built on a parcel that extends outside the original boundaries, and Brass Boys uprooted its practice facilities and moved them to another location which was part of the original parcel. So, and there was no contrary evidence. In fact, in the closing argument of Lakeside Babe, they conceded that they're only entitled to the restaurant parcel and a drain field underneath one of the tee boxes, and that was it. So they recognized even in their own closing argument that there was no evidence supporting an oral modification which includes the original parcel of the 2001 lease, the original parcel of the 1998 lease, which expired 4 years earlier, and the restaurant parcel as well. And even the trial court seemed to acknowledge that there was no evidence for that, because she states in her order that the evidence is not clear on what the boundaries are, and I'm going to leave it to the parties to work out. And that, we would contend, is also an error. It was the trial court's job to decide the controversy fully, not to say, I'm going to weigh in a little bit, but you guys work it out. The trial court had jurisdiction over the case. There was evidence presented, and it should have been decided, and it should have been decided based on the competent substantial evidence. And the only competent substantial evidence was the testimony of the two parties to the oral agreement, as well as there was a survey submitted as well to reflect those boundaries. So in conclusion, we would ask that the court reverse the trial court's denial of eviction. We don't think that the trial court had a valid legal basis for doing so, and we would ask that the court would reverse and remand for eviction. And in the alternative, we would ask that the court reverse and only insofar as the boundaries of the parcel determination are concerned. And this is an important issue because for title issues, and because the potential for, we have the potential of Brass Boys having to rip up its practice facilities and a whole shift in the status quo. And we would ask that, in the alternative, should the court deny eviction, which it should not, that we be remanded for determination of the boundaries of the parcel going forward.
Did anybody ask the court for the boundaries?
Yes, sir. Yes,
did?
yes. We had a declaratory judgment claim, the third claim of our complaint.
Yeah, that seemed to go to the validity, but I mean, you wanted her to say what the boundaries were too, I guess?
Yes.
Okay.
And in fact, she starts to do that in the amended final judgment, but then says, go ahead and you figure it out yourselves. Thank you.
Okay. Thank you both.